We all agree that national security is critical, but what happens when a tool designed to protect it actually ends up threatening the civil rights of the very people doing the protecting? That's the huge, high-stakes battle we're digging into today, and it's a conflict that could change the rules for thousands of federal employees.
It all starts with this number, 34. That's 34 years. The number of years a decorated intelligence analyst named Morter dedicated to serving his country. I mean, we're talking about a whole lifetime of distinguished service. So here's the question at the heart of it all. How does a 34-year career, with a perfect record, no security breaches, nothing, just get completely dismantled? Well, the answer, it turns out, reveals this massive fault line in federal employment law.
So yeah, we're talking about the case of Morter versus the Defense Intelligence Agency, but this is so much more than just one person's story. This is a case that really puts a core legal principle on trial.
So let's just lay out the facts. You've got a highly respected analyst, long, spotless career. He has a documented medical condition that makes him unsuitable for a polygraph test. And this is really important. Multiple security reviews confirmed he was still eligible for access and posed zero threat. And yet his career was effectively ended. He was forced into disability retirement. And here is the absolute crucial point. The entire conflict boils down to one simple question. Is a polygraph test an actual part of an analyst's day-to-day job, or is it just a security gate you have to pass through to get to the job? The legal answer has massive, massive implications for employee rights.
This really lays out the two sides of the argument perfectly. Is the polygraph an essential function, a core part of the work itself, or is it a qualification standard, just a prerequisite you clear before the real work can even begin? That single distinction, that's the entire legal battlefield.
So let's break down what the law actually says. An essential job function is the core work, right? The analysis you do every single day. But a qualification standard is just a periodic check, like a polygraph every few years. And notice the impact here. If you have to defer a polygraph for a bit, the core work, the analysis, continues just fine. That legal distinction is supposed to be a firewall. So this brings us to the central tactic that's being challenged here, something called definitional manipulation. It's a simple move, but it's incredibly powerful. If an agency just calls a screening test a job duty, they can suddenly argue they don't have to accommodate an employee with a disability who can't take it. They're essentially just relabeling a hurdle to get out of their legal duties. So you might be asking, how is this kind of thing supposed to be prevented? Well, the law is actually very, very clear on this point. There are specific regulations already in place to stop this exact scenario from happening.
The main legal shield for employees is the Rehabilitation Act of 1973, and its entire purpose is to make sure employees are judged on their ability to do their actual job, the analysis, and not get punished for a medical condition that prevents them from taking some side screening test.
And the law isn't vague about it either. The EEOC, that's the Equal Employment Opportunity Commission, has a clear evidence-based test. Like, how much time is spent on the task? For a polygraph, it's a few hours every 5 years maybe. Do thousands of other analysts do their job every day without actively taking a polygraph? Yes. The objective facts just don't show it's a daily essential duty. And here's the kicker. The Department of Defense's own rules say that agencies shall, and that's the key word, not may, but shall, postpone an exam for an employee who is medically unfit. This isn't a suggestion, it's a command. It's a mandatory safeguard that's supposed to recognize medical realities.
Okay, so we've seen the law is pretty clear. But why are these protections so critical? To really understand that, we need to take a quick look at the science of the polygraph itself.
So, according to the National Research Council, and these are basically the country's top scientific advisors, using polygraphs for this kind of broad screening is highly unreliable. It's just not accurate enough to base a career-ending decision on, especially when you think about how often it flags honest people as being deceptive.
This makes the problem incredibly clear. In a population of people who are already cleared employees, the number of actual security threats is almost zero. But the risk of a false positive, an honest person failing the test because of stress or a medical condition, is statistically high. So in this context, the tool is actually more likely to be wrong than right.
Now, if this legal decision is allowed to stand, it creates what experts call a template for evasion. Suddenly, any agency could just relabel a screening test as a job duty to get around accommodating disabilities. Trust becomes this vague excuse to remove people, and a distinguished career can be destroyed by a scientifically questionable machine.
So let's bring this all together. Why does one person's case against one agency matter so much to everybody else? Well, it's all about the principle that's at stake.
This fight is so much bigger than one person. It's a fight over whether the civil rights protections that Congress passed into law can just be erased with a simple change of labels. Can an agency really sidestep the law just by calling a security gate a duty? That is the fundamental question.
Ultimately, it comes down to this. We all agree national security is vital. But in that balance between protecting the nation and protecting the rights of the citizens who serve it, who's the final referee? Who ensures the rules are actually followed?